Within the franchising industry, California's recent passage of Assembly Bill 5 represents a very significant potential impact in the franchisor-franchisee relationship. And if you're a franchisor, if you're involved in the franchise industry, I'm sure AB5 is a topic that you're considering or you will be considering. And so today we're going to discuss what AB5 is and its potential impact on franchising itself. Before I even get into AB5, I have to say that the International Franchise Association has provided tremendous leadership as to this issue and its potential impact on franchising. So if you haven't had an opportunity yet, I would check out the IFA's lobbying efforts on this, and I would definitely support what the IFA is doing. So let's get into the detail. AB5, or Assembly Bill 5, was signed into law by the California governor this past September, and it'll take effect come January 1, 2020. AB5 is not franchise-specific law. In fact, it's a labor law, and what AB5 does is it restricts on what a California business owner could classify as an independent contractor versus an employee. So at a baseline level, if you're a California business, including if you're a franchise business, a franchise outlet, and in the past you relied on a workforce of individuals that you identified as independent contractors, well, it's very likely come January 1, 2020, you may need to reclassify these individuals as employees. And with that comes the increased cost and regulation of California's labor laws involving things like workers' compensation, minimum wage laws, overtime laws, all the typical labor law type issues that raise costs and are concerned to businesses. And just as an aside too, outside of the franchise industry, AB5 is really being focused on as a counterpunch to companies like Uber, or what people call as the gig economy, basically where technology and a company relies on crowdsourcing and an independent workforce of independent contractors. And a great example being Uber in relation to their ride-sharing drivers. Uber calls these ride-sharing drivers independent contractors. AB5 could potentially challenge that. So what does AB5 do? Well, AB5 actually takes California case law and legislates it. So in California, the Supreme Court, in a decision called Dynamex, right, in the Dynamex decision, gave a standard. It's called the ABC test. And it's a three-part standard that if under labor laws you want to classify someone as an independent contractor versus an employee, you need to make sure all three criteria are satisfied, A, B, and C. And if any one of those characteristics are not satisfied, you must classify the individual as an employee. So under the Dynamex ABC test, which is now the law of the land in California through AB5, the three-part test relates to control, scope, and trade, okay? So now if I were to go through these standards, let's assume we're looking from the perspective of a franchisee who's operating a franchise outlet in California, and they're working with a workforce. Do we call them independent contractor? Do we call the person an employee? Well, to call them an independent contractor, three things need to happen. A, this person needs to be free from the control and direction of your franchisee in the way he or she performs work for that franchisee. So that's control. There's freedom from control as to how they perform their services. The B part, which is scope, okay? The services being performed by the person we call the independent contractor relates to services that fall outside of the usual course of business of the franchisee, meaning what this person does is not something that your franchisee does in terms of the services and products it provides its customers. And the C part of this ABC test is trade. We have to look at whether or not this individual that your franchisee is working with, separate from your franchisee, is independently involved in this trade or occupation for which he's providing services. So that's the ABC test, and all it is three criteria that California businesses need to satisfy before they could call someone an independent contractor. Significance of this is it's much more restrictive. And it's very likely that what was referred to as an independent contractor in the past now needs to be referred to as an employee with all those benefits. So what's the impact on franchising? There's a couple of things here. At the most basic level, right, I'll call it risk factor 1, if your franchise system and franchise model involves franchisees that rely on an independent contractor workforce, then in the state of California, naturally, the most direct impact is that it's very possible those independent contractors now need to be classified as employees. And so at a base level, AB5 could be impacting your business model and the viability of your business as a franchise system in California. But that's the same risk that every other business has there. Going back to this risk 1, or I'll call it the primary risk to franchisors, if as a franchisor you were to have joint employer liability with this franchisee, well then naturally another concern is that if your franchisee misclassifies its employees, meaning it calls someone an independent contractor when they're really an employee, if you have joint employer liability, then that employee can sue you, right, for a labor violation in California. And that's a risk we've always had and something we've been talking about for many years in terms of joint employer liability and creating those protections, right? For example, as a franchisor, up to now, to avoid joint employer liability, you needed to put in some firewalls, like absolutely not getting involved with franchisee hiring, firing decisions, setting payroll, time off, those types of things, right? Clear delineations where you cut yourself off from franchisee decision making. So risk 1 is if your franchisees rely on independent contractors, there may be a threat to your business model, at least its economic viability. Also, if there's joint employer liability, you could have labor law violations in California. Risk 2 is the one that I think the IFA and many industry professionals, including myself, are the most concerned with. And this, I will tell you, is not clearly established yet. It's absolutely evolving. And the concern is this, that if a court were ever to apply this ABC test to determine whether or not a franchisor should have joint employer liability. And so I'll explain. Dynamex was the court decision that came up with this 3-part test, right? Control, scope, and trade. And said if to call someone an independent contractor, you need to meet all this criteria. What happened after Dynamex was a decision in California in the Ninth Circuit involving JanPro franchising. It's Vasquez versus JanPro. This litigation's been going on many years. It's been involved in many different courts. And of course, it involved plaintiff franchisees suing JanPro franchising, claiming that the janitor plaintiffs were classified as independent contractors when they should have been treated as employees. Now, under JanPro's model, at least in the Vasquez decision, they talk about master franchising. So JanPro Franchising International sold master franchising rights. The masters sold individual franchises, and individual unit franchisees hired janitors. In the Vasquez decision, the Ninth Circuit held open the possibility that JanPro Franchising could have joint employer liability to the janitors who claim under California law they were wrongfully misclassified as independent contractors as opposed to employees. Now, what's really significant about Vasquez, and it's still not clearly decided, the case is ongoing, and so this is unsettled law. The Ninth Circuit in Vasquez did 2 things. One, it held that the ABC test from Dynamex applied retroactively. And 2, the Ninth Circuit held that the ABC test could be applied to franchising and in determining whether or not there's joint employer liability between a franchisor and its franchisee. That's the significance here, right? And again, it's not fully fleshed out, and this is evolving. So there's concern about this Dynamex case law. Now, AB5 as a law expressly refers to Dynamex, and its intention is to incorporate the Dynamex ABC test. There's no exclusion in AB5 for franchising itself, and the concern, and my concern, and the IFA's concern, I believe, is that as AB5 gets litigated in courtrooms, plaintiffs' attorneys, right, labor attorneys representing individuals who claim they were misclassified, will attempt to argue in California courts that under the Vasquez decision and now AB5, franchisors should be subject to this ABC test in determining whether or not a franchisor is joint employer liability. And the reason why we don't want the ABC test to be applied is because it's a much lower or less stringent standard than what the current case law on joint employer liability. Right now, you need, as a franchisor, to have control over hiring and firing decisions and a bunch of policies, whereas under the ABC test, the standard would almost always be satisfied, and franchisors could theoretically have open-ended joint employer liability. So this second risk factor is a structural one. It appears that the intention of AB5 is to not modify joint employer or liability in California, but that's not clear, and that means the franchise industry could be prone to bad case law or decisions in California that apply this ABC test, which, if it happens, would be a drastic impact on the franchising model in California. So what can you do as a franchisor? One, I definitely recommend get involved with IFA's lobbying efforts. They've been amazing on this issue. Two, if as a franchisor, this is not going to solve everything, but make sure your model is, two things. If your franchisees are dependent on an independent contractor workforce in California, then you need to meet with your franchise team, meet with your franchise attorneys, and discuss a game plan to ensure that franchisees are compliant with California law without, in that process, exposing yourself to joint employer liability, right? If your franchisee workforce is not dependent on independent contractors, then at this initial early stage, there may not be a very big direct impact. Long term, the bigger issue is whether or not plaintiffs' lawyers abuse this new legislation, what happens with the Vasquez decision, and whether or not courts are going to loosen the standard to create joint employer liability for almost every franchise relationship. So this is an issue that's definitely evolving, and we'll be following up on it from time to time.